Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Okay, but there's also drug offender probation, is that right?
Yeah.
Okay, all right, I'm gonna write it up, I'll see if I can talk to
She
him.
went to Alachua County Court, so there's no reason she won't be here.
Okay, all right, and we'll just send her across the street to my office.
Yeah.
The paperwork comes.
She'll be stuck. She'll just have to take it from her, because that's like, you need to be prepared to pay it. Yeah, in every time.
Well, I didn't know that, so that was, yeah, that was
Well, that's
a
a
new one.
And that's why I told her, just be prepared, because I just want to cancel for sure. So you'll have to.
Okay, cool.
Awesome. Thanks. All right. This is
All rise. Court is now session. Honorable John Brown.
sit here tomorrow without getting to a coordinate.
What is your version of the curfew on drug offender probation?
Well, it depends. Normal is 10 to 6, but we don't want that. So, it's too far. Judy would have liked to do 7 to 7, 10 to 6, she could do.
You have anything?
It's 10 to 6.
Okay.
But it can be adjusted.
I don't know if we adjust it. I know sometimes.
So, judges, private judges will do 7 to 7.
Okay,
That's
that's
7 to 6.
That's why I was asking. Cover for Jason.
Yeah.
Got drug offender probation.
Yeah, but I mean, it's, you know, they're typical.
That's typically what I have.
Yeah.
Okay.
But, like I said, you can
To private counsel, Mr. Darman, you first.
Good morning.
Morning, sir.
I have one case on Malcolm Hawkins, 15 CF 443.
Mr. Klein?
Every now and then.
Mr. Klein?
Oh, I'm sorry, Your
You
Honor.
hold it down.
Yeah, I'm sorry, Your Honor.
Thank you.
Judge, Mr. Hawkins, 15 CF 443. The state has agreed to dismiss the VOP and revoke and terminate probation. He will owe the cost of transport, which is $338.20. He is able to pay that today. So if the clerk is able to input that, he can call and make that payment.
Okay. Is that the state's agreement?
Yes, Judge, this is an unusual case because the warrant was never served on the defendant. This is a 2015 case. Proof of the anger management, parenting classes, and the psych evaluation has been provided to the state. So at this point, we'd be asking the court to dismiss the VOP and terminate his supervision, as well as get that cost of transportation paid, hopefully today.
Okay. Yes, ma'am. That is granted.
Thank you, Judge. Have a good day.
What was that amount?
$338.20.
Thank you.
Thank you, ma'am. Thank you.
Thank you. Yes, sir. Ready?
Yes. Good morning, Your Honor. Tim Weaver on behalf of Carlos Pena. Your Honor, this is a case that we set today just for a status conference. He got a ROR bond a few weeks ago, and but it turns out that immigration picked him up and took him to another city. They're trying to proceed on that case, but without any decision on the case here. The language from the information looks pretty bad, and it looks actually, I think, quite frankly, worse than it is in actuality. But so we're trying to reach a resolution. We seem to be making progress, but taking a deposition of the alleged victim here, and we think we may be able to reach a resolution. But I think at this point, you've continued the case into to July 10th. What I'd like to do is just, for the sake of one way trying to resolve this, get a definite trial date if we have to try it in July. And I'd like to kind of set that date so that we know that you're either going to bring him back or we're going to resolve it. But I've got to bring this to an end because I'm in a catch-22 between they can't do anything down there until we do something here, but I can't do something here without him here, so.
Mr. Gomez?
I think I'm in agreement with defense counsel. I think we want to leave it set for that July 10th pretrial date with the idea of going to trial in July if we do not have it resolved. We're hoping to have it resolved, but as defense counsel has said, there is a little bit of some different hurdles that we have to get over and with respect to the victim and also with the situation with immigration. So we're working through that, but we would like to get this resolved at the very latest in July at a July trial. So we would just like to leave it set for the July 10th date.
Okay, so Mr. Weaver, do you need an order that says, do you want to prepare a proposed order that says pretrial is July 10th, docket day is July 17th, jury review is July 20th, and the trial date will be July 24th?
Yes, I believe
Okay,
so.
it's July 10th, 17th, 20th, and 24th.
And I'll prepare an order that it's being set for that day.
Yes,
and like I say, we're trying to arrange a little bit of protection for the alleged victim if she believes she needs it. We're going to set up a conference with her, and maybe she'll do a civil injunction if she's capable of filling out that paperwork. Maybe we'll find some other way of giving her a little protection. We just don't want this to be resolved and then something happen. I don't really think it will with this guy and with these people, but I understand the state's position. They want some assurance And we're trying to figure out a way to do that, and also dealing with a language barrier at the same time. So it's been a little difficult. But
that is a possibility. You know, you may talk about a stipulation between the alleged victim and the defendant in the domestic violence court and see if the judge would enter that. If that is something that would be palatable to the state. So just, I understand your argument.
I think everybody thinks it's a good idea, just trying to figure out how to get there from here, because, but,
Yes, sir.
okay.
Okay.
So I will prepare
see you
that.
back here on July 10th.
Okay, and I'll prepare that order. Thank you, Your Honor.
Sounds good. Thank you. I've got an iPhone, but I don't know who's on the iPhone. They're muted. Whoever's on the iPhone, if you'll unmute your microphone and tell me who you are. If you don't unmute your microphone, then I'm going, hey, what? Nope. If you don't unmute your microphone, then I'm going to exclude you from the hearing. Ask you one more time. There we go. No? They disappeared, but now they're coming. There we go. Yes, ma'am. What's your name? On the iPhone? Shanae. Shanae. What's your last name? Ms. Tatum? Yes, sir.
Good morning, Your Honor. Ryan Morrow from Ms. Tatum. Ms. Tatum, can you hear us okay and see us okay?
Yes, sir.
Your Honor, Ms. Tatum, the state's made an offer to resolve her VOP, to vote terminate and send the financials to a lien. I didn't know if the court would be willing to take that this morning over the Zoom.
Yes, sir. Okay, and so it would be, what would be the adjudication?
She's previously adjudicated on the underlying misdemeanor, Your Honor.
So guilty of a misdemeanor?
Yes, Your Honor.
And then what would be the sentence?
We'll be revoking and terminating the supervision and sending all outstanding financials to a lien.
Okay, including a $100 cost of prosecution and a $150 public defense.
Correct, Your Honor. Thank you.
Okay. Ms. Tatum, if you'll raise your right hand. I can't see your, there you go. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Tatum, so did you understand what your attorney, Mr. Morrow, stated?
Yes, sir.
Do you understand that if I accept your plea that you're waiving your right to a trial by jury? Well, no, I'm sorry, this is VOP, right?
It is, Your Honor.
That you're waiving your right to an evidentiary hearing where the court would have to find that you violated probation after hearing the case from the state. Do you understand we're not going to have that?
Yes, sir.
Ms. Tatum, I do accept your plea. You're adjudicated guilty of the misdemeanor. Your current supervision is revoked and terminated. All outstanding financials, including the $100 cost of prosecution, $150 public defender's fee, are sent to a civil lien or judgment. Thank you, Ms. Tatum.
Thank you, sir.
Yes, ma'am.
Thank you.
Okay. Next, private counsel, Mr. Grubb.
Thank you, Your Honor.
Yes, sir.
May it please the court, Dustin Durrell on behalf of Mr. Derek Wilson. Mr. Wilson is present, Your Honor. Your Honor, I was speaking with the state on this one. I believe we're close to resolution. We are currently looking for a rehabilitation program for Mr. Wilson that can accept him with his finances. If we may have a continuance on this to see if we can get the application process done, get him enrolled somewhere, I believe that will resolve this case, Your Honor.
Okay. How long do you need?
If we can have, I would hope a month. It would be plenty of time to find an appropriate program for him.
Yes, sir. Why don't we do it on June 15th at
Yes,
9
sir.
o'clock? So, Mr. Wilson, I'll see you back here June 15th at 9. Good luck on finding that program.
Thanks, Your Honor.
Yes, sir.
Thank you very much, Your Honor.
Thanks, Mr. Drill. Yes, ma'am. Ms. Jacob.
The first I have is Edward Maldonado in 22 CF 2491. Your Honor, we did file a motion to dismiss in this case, and the state has not filed a traverse at this time.
Your Honor, that's correct. The state has not granted file a traverse.
And based on that, Your Honor, I'd ask that the court dismiss the charges against Mr. Maldonado.
Mr. Maldonado, your case 22 CF 2491 is dismissed. Thank you, sir.
And Madam Clerk, just to verify, that removes the $50 application fee from the case. Okay, so you'll need to pay the $50. Okay. You could pay it today or tomorrow, just pay it.
Thank you.
Thank you, Your Honor. The next I have is Robert Rice in 22 CF 843 and 22 CF 856. This is a status on the competency reval. The court previously waived Mr. Rice's needing to be transported. Your Honor, Mr. Rice, the jail had actually attempted to have Mr. Rice meet with a psychiatrist. He refused to meet with that psychiatrist, and then Dr. McDonald tried to go and meet with him yesterday, and he refused to meet with her as well.
So what are you seeking?
Your Honor, I'm not seeking anything. I objected to the reevaluation. So I'm, again, just renewing my motion to have the charges dismissed at this time.
Okay, thank you. Yes, ma'am.
Judge, I think an order needs to be entered that requires the jail to have Mr. Rice attend that evaluation.
Okay. I agree. Yes, ma'am. If you'll prepare a proposed order, then I'll sign it.
Yes, sir.
So do we want to put Mr. Rice on the next date we have, which is June 12th? Or do you want it after that?
I would say we go ahead and schedule it for the 12th. The sooner the better. If things aren't done, we can always continue another week or two, whatever Dr. McDonald would need in order for the evaluation to be done. But I would think we need to keep hands on it as much as possible.
And Your Honor, I was just, the reason I was thinking, I know I have some stuff scheduled on the 15th already. I would just ask we put it on the 15th instead of the 12th.
Yes, ma'am. Okay, so June 15th at 9 o'clock.
Thank you, Your Honor. And the last one I have is Keandria Williams, Your Honor, and she had a little trouble finding the courthouse this morning because she is here from out of state. So if I could just have a moment to have her sign the plea agreement, I'll be back with the court.
Yes, ma'am. Just let me know when you're ready.
Thank you, Your Honor.
Thank you. Mr. LaPella, are you ready?
Yes.
Good morning, Your Honor.
Good morning, sir.
Stephen Everly is my client today. We have a motion before the court on a motion for early termination. He's completed 38 out of 60 months of supervision. We tried to time the motion hearing. It's hard to get things scheduled and know exactly when they're going to be set for. We tried to schedule it close to the 2/3 mark. So he's right there. He's 38 out of 60 months. So that's just less than 2/3. We're asking the court to early terminate his supervision.
Okay, to the state.
Judge, we'd be objecting to early termination at this point. He pled to the court in November of 19 to using a computer to facilitate or solicit sexual conduct of a child and traveling to meet a minor. In March of 2020, the court granted the defendant a downward departure of a reverse split sentence. That was the first 2 years on CC, followed by 3 years of probation, with 10 years of Department of Corrections suspended as a reverse split. He received a very significant break up front in this case from the court. He has not been a model probationer. He did receive a VOP less than 30 days after being placed on probation. According to the report on Benchmark, it was for having a smartphone and being untruthful to the officer about it. Given the nature of the charges, the risk to the community, and after speaking with his probation officer, Mr. Gamble, who does not recommend early term in this case, we'd ask the court to deny defense's motion for early termination.
Okay, thank you. And when you mentioned about not being truthful, I believe the docket shows, or the violation report shows that at that time, and let's see when that was 2020, that the defendant said, no, I didn't use this phone to search anything, and then they opened the phone up and found that he had searched things. Mr. LaPella?
Yes, Your Honor. We were before the court in October October 10th of 2022 on a motion for early termination after he'd completed more than half of the supervision. The court at that last hearing indicated that the court needed to see a little bit more time, and the implication or the inference that we got out of that is that 2/3 would be contemplated. That's why I have the court minutes here where it says denied without prejudice. I don't have the transcript from that hearing, but I do recall the court's comments that saying, the court, Your Honor, wanted to have more time, wanted to see my client under supervision a little longer.
Right, and I think the first 2 years were community control, right?
That's correct.
So that was when you came back before, was pretty close to that. He hadn't been on probation very long.
Mm-hmm.
So I understand why I said that at that point, because I wanted to make sure that he could fulfill the less stringent requirements of probation for that time period. I don't know if at that time that I grasped the untruthfulness as far as using the cell phone back in 20. Mr. Everly, respectfully, and I'm sorry if I led you on, but the motion for early termination is denied. Thank you, sir.
Is there any situation, Your Honor, where the court would consider early termination in this case?
Well, and that may have been what got me here from a year ago. I can't predict the future. I don't know, and I certainly am glad that Mr. Everly's doing everything that's required of probation. I can't tell you what I'll do in a year. I just don't know.
I understand, Your Honor. Thank you very much. And this is without prejudice, though, for him. If he does successfully complete a certain amount of time going forward, that the court would reconsider this.
And by saying without prejudice, I mean, I think that, and I did see that in the record when I was doing my homework, because I thought that's an unusual way for me to do it. If you want without prejudice, certainly that's without prejudice. But I think by the passage of time, even if I denied it without saying without prejudice, the passage of time would allow you to file it later anyway. But I'm fine with putting without prejudice. Okay. Yes, sir.
Because my understanding, I believe the court was aware of the prior violation.
Yes, sir.
Because I think it's like too obvious not to be aware of that. I mean, not the court, but the state would have brought it up at a hearing. So I'm surprised that it's an issue here. But very well.
I just didn't have it. When I looked for any prior paperwork on Mr. Everly, I didn't see any, and so I printed it off new. Hopefully this will stay between now and then. But thank you.
Thank you, Your Honor.
Yes, sir. Thank you. Okay. Can't tell who's behind. Okay. Yes, sir. Yes, ma'am. Studley, you ready?
Yes, sir.
Thank you.
I just have one. Roselle Payton, he's an inmate. He's 20 CS 1798.
Well, Mr. Payton. Good. How are you?
We're in a denial today. We're still waiting on discovery in this case and the new law case. We could set this to track with the 23 CF 937 case. I believe it's on the July pretrial docket.
Okay. So, Mr. Payton, I'll see you back here on July 10th on both of your cases, unless your attorney sets a hearing before that date.
That's all I have, Your Honor.
Thank you, ma'am.
Thank you.
Any other private counsel? I don't see any. So then the pro se's, the defendants that don't have attorneys, Christopher Long, 22 CF 967. Well, Mr. Long. Mr. Long, do you, well, let me ask the state, do they have an offer for Mr. Long?
I think, Your Honor, this really deals with payment. So our offer would be that if he believes that he could pay it, we would want to give him some time to do that. And if we wanted to set it, maybe, I don't know if he needs 1 month or 2 months, from what I understand, and probation can correct me if I'm wrong, he's $2,648 in arrears for, I believe this is, well, that one's restitution payments total. There's $340 in arrears for, I believe, J-Pay system. There is $250 to a Kim Murphy Hill. And I believe he still owes, I think the $340 is actually court costs, but essentially, if he makes good faith payments, then, and he does pay it off, then we'd be willing to eventually dismiss this VOP. However, if it's a situation where he doesn't believe that he can make the payments, then we would offer a county jail sentence to revoke and terminate.
Okay. Mr. Long, you have the right to an attorney. I can appoint one if you qualify financially. You have the right to, if it's true, just tell the state, hey, I think I can start making these payments, and we'll give you some time before we bring you back. It's up to you. What do you wish to do?
I am able to make the payments based off of what my probation officer had told me was they did not have an address for the USAA payments to be made. So when I had asked originally where the payments were going, she said she didn't know. So that was the reason why the payments just were not being made.
Okay. Probation, anything to enlighten the court?
Well, I'd love to, but we do have an address for USAA. We just have to get it in the system. So, but he does terminate July the 16th. So after that time period, he will not be supervised any longer. But I will make sure that that USAA gets put into the system, and so that way he can make those payments for restitution.
Correct me if I'm wrong, but doesn't the period of supervision toll once you filed the violation of probation?
Not unless, well, kind of yes, but we no longer supervise anybody past term. It stops.
Okay.
Mr. Long, do you think you can pay? It looks like it's probably over $3,000. Can you pay that before July 16th?
I believe so, yes.
I mean, Judge, and speaking candidly, I think if there was a good faith effort that he made significant payment, once we came back on that in that July date, I think the state would be amenable to taking that into account that he did make a significant payment. I think we want it first and foremost to go towards the restitution payments, and then if we can go from there towards the arrears for any good cause of supervision or anything like that, that would go a long way in the state, being willing to resolve this case.
So, Mr. Long, I'll see you back here on July 13th at 9 o'clock. Pay as much of that as you can. That'll make your case that much stronger. If it's not all paid by that time, or if the state doesn't say you've paid enough where they're willing to put the balance of it, I think, like the state says, restitution is probably their number one concern. The other amounts may go to a civil lien or judgment if they agree to that. If the state does, if not, then I'll appoint a public defender if you qualify financially. If you make over $2,000 a month, you probably won't qualify for that. So you'll either be representing yourself at that point, or you'll need to be bring a private attorney with you. Okay. So I'm telling you everything that I know. Where when we get here just a few days before your supervision terminates, kind of know where we are. Okay.
Okay.
Thank you, sir.
Thank you.
Yes, sir. Daryl Shaw is next. Daryl Shaw. Okay. Yes, ma'am. Got it. Well, Mr. Shaw, if you'll just come to the lectern. Thank you, sir. This is case number 15 CF 1264. To the state, what are you seeking regarding Mr. Shaw? Do I need to appoint a public defender?
Yes, Judge. Mr. Shaw scores a significant amount of time according to his guidelines.
Mr. Shaw, do you want me to appoint the public defender if you qualify financially?
Not at this time.
Okay, so you're going to represent yourself?
No.
Okay, you're going to hire a private attorney?
I would like to.
Okay. Because the state, all I can make y'all do is either go to a jury trial if it's the underlying case, or go to an evidentiary hearing. You know, a judge trial to determine whether probation was violated or not. So that's where I'm marching on your case, because this is a VOP case. If you're going to hire a private counsel, then certainly I want you to do that. But you need to do it sooner than later, and then I would set it for, I guess, probably a hearing without subpoenas, without the actual trial, and then be looking at setting it for trial soon after that.
Okay.
So if you're going to hire a private attorney, do it sooner than later. If you decide that you're not going to do that, fill out the financial paperwork, the affidavit at the courthouse, and file that with the clerk and see if you qualify for the public defender. If they say you don't qualify for the public defender, there's a place for you to appeal it to the judge to look at that, and I'd encourage you to do that where we can get a second look at it.
And that decision can be made
without a hearing.
right
Yes, sir.
at a later time.
Right. When you send in the paperwork, the financial affidavit to the clerk will make an administrative determination whether you qualify. If they do, then you will immediately be appointed a public defender. If you don't, appeal it, let the judge look at it, and then if you qualify, we'll appoint one. If not, then you'll be back here without an attorney. And you can always do that.
Okay, I think I understand.
So the next date that I have is June 12th. So to the state, any objection to us setting it for a status on June 12th, with the understanding that I'll be looking at setting it for an evidentiary hearing shortly thereafter.
No, Judge, that seems appropriate.
Okay. Mr. Shaw, I'll see you back here on June 12th at 9 o'clock.
12, 9
Yes, sir. Thank you.
Your Honor, may I call one case out of order before
Sure,
I step out?
Mr. Morrow.
Mr. McGill.
Mr. McGill?
Yes, Your Honor. Ryan Morrow for Mr. McGill. He was passed to complete requirements from our last court date. It's my understanding he has completed those requirements, so we're hoping that the state will be willing to place the affidavit.
Yes, Your Honor, that's correct. I've been in contact with probation. Mr. McGill has completed all the requirements, and this time the DOT will be dismissed and his probation will be terminated.
Excellent. Good. Mr. McGill, then your supervision is terminated.
Thank you, sir.
Thank you, sir. Yes, ma'am.
Thank you, Your Honor. If I may call Keandria Williams. Ms. Williams is present and approaching.
Good. Thank you.
That case number is 22 CF 3136. We have reached an agreement in her case. Your Honor, we will need to submit a score sheet at a later date, but this is a guidelines offer. Count 1, the state will announce a null pros, and count 2, she'll be adjudicated guilty. She'll be placed on 5 years of probation, which will run concurrent to any other supervision she's currently on. We're going to stipulate to waive the cost of supervision given the amount of restitution. She will need to pay the $515 in court costs, the $150 cost of defense. She will need to submit to an anti-theft course. However, an online course would be acceptable. She will need to pay $15,580.42 in restitution to Walmart Destin. That address is 15017 Emerald Coast Parkway in Destin 32541. That will be joint and several with any of the co-defendants. She will be allowed to automatically terminate at 3 years if she's completed all the conditions and there have been no violations. The state has no objection to transferring out of state upon approval from the Department of Probation and Parole. We have already begun that process with probation, so she should be good to go. And she also was advised that the cost of supervision may not be waived once she transfers. And that would be up to Michigan to determine. And she may already know that information for her Santa Rosa probation being transferred already. So may I approach?
Yes, ma'am. Ms. Williams, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Williams, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes.
Are you satisfied with her representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Williams, I do accept your plea. You're adjudicated guilty on count 2. Count 1 is dismissed. You're sentenced to 5 years probation, and that's to run concurrently with any other probation or supervision you're on. The court waives the cost of supervision. You'll need to pay the court costs, $150 public assistance fee. Take the anti-theft course. You can take that online. You'll need to pay restitution in the amount of $15,580.40 to Walmart of Destin, and that's joint and several with the co-defendants. Your supervision will automatically terminate at the 3-year mark if you haven't committed any new law violations between now and then and have successfully completed all the terms of your supervision by that time. Court has no objection to you transferring your supervision out of state, but make sure you get the okay from probation here before you leave. Okay?
Thank you.
Thank you, ma'am.
Thank you, Your Honor. That's all I have this morning.
Thank you, ma'am.
Thank you.
Yes, sir. Mr. Kilpatrick.
Good morning, Your Honor. Keith Kilpatrick representing Michelle Ulrich, U-L-R-I-C-H. She is in custody as she approaches the lectern. She's before the court in 2 case numbers, 20-CF-1718 and 20-CF-2285. They're both
She's
violent.
also known as Miss Silvers.
Yes, sir.
Yes, sir.
Okay, and you, her last name now is?
Ulrich.
Okay.
She was married.
Okay. Yes, sir.
She's going to be entering an admission of guilt to the alleged violations in both case numbers. The agreement with the state asks to a sentence is to adjudicate her guilty on both cases. It's going to be a reverse split sentence. Her sentence, her current probation is going to be modified for the next 18 months will be drug offender probation, followed by 24 months of Department of Corrections with credit for time served. She's going to have to successfully complete the teen court challenge, and it's going to be automatic termination upon the successful completion of the teen court challenge. And teen challenge, she would be adjudicated or waive any precedence investigation. May I approach?
Yes, sir.
I didn't know what the fines and costs would be, Your Honor.
Okay, thank you. To the state, as far as money?
Judge, it should be a total of $200 cost of prosecution, $100 per case.
Yes, ma'am.
And I do believe that she had a public defender previously, so there would be the $50 application fee.
Okay, thank you. Okay, so if Ms. Ulrich completes teen court before the 18-month drug offender probation?
Teen challenge.
Okay.
Teen court.
Teen challenge. If she completes that before the 18-month drug offender probation terminates, then her supervision is going to automatically terminate.
Yes, Judge, and the suspended, or the DOC sentence would also go away.
Right. Okay. Ms. Ulrich, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Ulrich, I can tell by your smile, you know, it's an interesting plea agreement. The terms of it are they're unique. When I was practicing law, the first thing I thought about when my clients came in was I wanted to make sure they understood the downside, because the upside will take care of itself. So the biggest downside is if you fail to successfully complete your supervision, what happens?
Out of prison for 24 months.
Okay, that's the main thing I wanted you to know. Ms. Ulrich, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
No, sir.
Nope. Right, you didn't?
This is exactly the document that we went over.
Thank you, sir. Now, Ms. Ulrich, have you signed the plea agreement?
Yes, sir.
Okay. Ms. Ulrich, again, very unique the way this is. That's why I asked it pointedly, that, you know, it's very specific on the first 18 months in drug offender probation. Well, the entire supervision is that, but then to be able to auto-term after teen challenge, very unique. So you are adjudicated guilty. Your current supervision is modified so that the next 18 months are drug offender probation. However, you're also to enter and successfully complete the teen challenge program. If you do that, then your supervision will automatically be terminated. If you fail to successfully complete your supervision, then you're sentenced to 24 months with the Department of Corrections with credit for all time served. You'll need to pay the $200 cost of prosecution and the $50 application fee. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand that?
Yes, sir.
Thank you, ma'am. Good luck to you, Ms. Hall.
Thank you. Thank you.
Thank you very much, Your Honor.
Yes, sir. I don't see any other private counsel. Mr. Klein, you ready?
Your Honor, I just have Mr. Losey on the docket, or I have Mr. McKinney's docket also. Do you want me to call Mr. McKinney's out of custody?
Whatever. Yes, sir. That'd be great.
Okay. First, I'll call Eric Watkins. Mr. Watkins is present and approaching, Your Honor. Looks like there's the basis for this violation is an alleged misdemeanor that's currently pending. I would ask the court for to continue this to the last available date in June to try to get that misdemeanor resolved.
Okay. Mr. Watkins, how are you? Good, doing well. Thank you, sir. So, Mr. Watkins, I'll see you back here on June 22nd at 9 o'clock. Stay in touch with Mr. Kleins, okay? June 22nd.
All right. Next on the morning docket, Joel Walls.
Joel Michael Walls, 21 CF 1796.
Your Honor, Mr. McKinney's notes indicate this was only on for status. It looks like there was a motion to suppress that was filed on March 6th that is set for a hearing on June 19th. I don't have any other information for the court.
Judge, the state had made an offer to Mr. Walls for a lesser trafficking amount, so it would be a 3-year min-man instead of the 7-year min-man. That's what this court date was supposed to be for, was to hoping for Mr. McKinney to have some communication from his client before today, and then Mr. Walls to appear today in order to address the court on whether he was going to accept that offer.
Okay, he did appear, according to the minutes, on April 20th.
Yes, Judge.
The defendant, that is.
Yes, Judge.
Okay.
I would just simply ask the court to put this on, and I know the court doesn't want to burden the jury review docket. However, I don't have all the information Mr. McKinney does. I have not personally talked to Mr. Walls. I'd hate for the court to issue an arrest warrant in a situation where possibly Mr. McKinney's discussed this with him and advised him not to be here. I don't know. But Mr. McKinney will be back for jury review. So if the court wants to leave this on for jury review so Mr. McKinney can fill the court in himself.
Well, it was interesting. It says the motion to suppress is continued until June 19th.
That's his notes indicate, and I did check. The motion to suppress was actually filed on March 6th. I don't know why.
So, and then it talks about July 10th, but the next time, I'm not going to issue a capias for Mr. Walls today, but he needs to be here on June 19th at 1:30.
Absolutely. I'll make a note of
Put
that.
on notice of that.
Yes, sir.
Judge, at this point, the state's going to withdraw any offer on the case.
Okay. Thank you.
It looks like everybody else that I'm going to be dealing with is in custody, so.
Okay, but then you have the other folks that are in the gallery?
I don't know who they're here for. Everybody else that I have is in custody.
Okay. Those of you in the gallery, if you just want to come up, yes, ma'am, come on up to the lectern and let's figure out what's going on.
Yes, sir.
You can bring your paperwork.
I was going to say, let me go get Mr. Morrow. I have a feeling that number is in
They're all Mr. Morris? Okay.
Who in the gallery is here for an inmate? Raise your hand. Thank you.
Good.
Keep your hand up. Who are you here for?
Great call, Allison. Thank you.
Anyone else? Hand up.
Who's Morrow?
No, that's it. Quite all right.
I apologize for holding up your court, Your Honor.
Mr. Morrow, your clients that are in the gallery?
Anyone else? Here for an inmate? No?
Christian Whitworth.
Thank you.
Ryan Morrow for Ms. Williams, Your Honor. She's before the court today, having passed to allow time to make a payment. May I have a moment with Ms. Williams? While
Yes,
here
sir.
at the bench. And what I have here at the podium is a receipt showing a recovered amount of $3,180, and she does still have about $10,000 outstanding, is what I'm showing. I don't know if the court will be willing to pass her again for compliance, but the state would have a rejection at this point.
I have no objection to that.
Okay. Ms. Williamson, how are you?
Good, how are you, sir?
Good, doing well. So I would assume that the further, the better, right?
I'm sorry, Your Honor?
The further out we can set the hearing, the better?
I would say so. With what's outstanding, Your Honor, yes.
Right. To the state, how long are you willing to go for a continuance?
I mean, I'm willing to give her as much time as she feels like she's needing to, as long as she's making the payment.
So do you want to do it at the end of August?
I'm okay with that, Your Honor.
Okay. Ms. Williamson, I'll see you back here on August 24th at 9 o'clock, okay?
May I write that down?
Yeah, sure.
9 a.m.?
Yes, ma'am.
Yes, sir.
Thank you, ma'am.
Thank you.
Yes, ma'am. Mr. Marlowe, who else do you have?
I'll call a few from the gallery, Your Honor. Tristan Whitworth.
He is an inmate.
He's not listed.
And she's waiting for him. Do you want to do Mr. What?
Ticket number 22.
Mr. Kleins, when you were out, Allison asked the folks in the gallery which inmates they were waiting for, and she has those names.
Okay, and Mr. Walls is here too, so if we want to take him back to put that on the record.
Okay.
Whitworth, yes.
Ryan Morrow for Mr. Whitworth, Your Honor. He did not show up on my jail list. He's not listed as an inmate on the docket. I was unaware that he was in custody, or I would have seen him before today, Your Honor. Would the court be willing to pass him to our next available miscellaneous date so I can confer?
We can do it today. I'm okay. I just want to see if we could reinstate him on probation.
Right, understand. Is there an offer to Mr. Whitworth?
Your Honor, the state's offer is to reinstate and modify the probation, but with Phoenix House and Project Hope as a component. So I'll confer with Mr. Whitworth, see if that's something he's interested in. I'll have an evaluation conducted, Your Honor.
Okay, so how long do you want to set the next hearing? How far out?
I would say at least 3 weeks for those evaluations, Your Honor, whatever's closest to that.
Could I see if I could just reinstate the probation and pay off the courts and fines?
Well, the state's not offering that. Your attorney can
Okay.
ask the state for that.
Okay.
That was why I was asking.
Okay.
Judge, the only other offer that the state would make is on Mr. Whitworth. He scores 45.4 points. So it would either be he complete an extensive inpatient program with either Project Hope or Phoenix House, or the state's going to be asking for a guideline sentence of 13.05 months.
Phoenix House.
Yes, sir. So why don't we set it for June 15th at 9 o'clock?
Thank you, Your Honor.
Thank you, Your Honor.
If you get, hold on 1 second. Mr. Morrow, if you get an answer before that time, and the state's willing to enter into a plea, then, you know, during the jury trial week, we can do it first thing in the morning, we can do whatever, okay?
Understood,
So
Your
don't
Honor.
wait that entire time. So, Mr. Whitworth, I'll see you no later than June 15th.
Thank you, sir.
Thank you, sir. Mr. Morrow, anybody else in the gallery that you have?
Do I have Jeffrey Green?
Mr. Green?
Ryan Morrow for Mr. Green, Your Honor. He's got 3 matters before the court. The state has suggested drug court as a resolution in this case. I'm going to connect him with Terry Henderson, and I'll reconfer. I would ask if we could have that June 15th date for Mr. Green as well.
Okay. Mr. Green, I'll see you back here on June 15th. I hope that you get accepted into drug court. If you make it through that, then your cases are dismissed. They have a lot of tools that I don't have. They'll really look over your shoulder. They'll make sure that you're doing what you need to do. But at the end of it, you come out relatively unscathed. So I really hope you get in.
Yes, sir.
Thank you, sir.
Thank you, Judge.
MC Carter.
Mr. Carter. Well, Mr. Carter, how are you?
How you doing, Your Honor?
Ryan Morrow, Mr. Carter, Your Honor. I'm not sure if this is his first time up. I was recently appointed to this case. I hadn't had an opportunity to confer with Mr. Carter. I'm going to
Is
hand
there
him
an
a card.
offer to Mr. Carter from the state?
From what I understand, this was a situation where he just needed to pay the remaining balance, if I'm not mistaken. We wanted to give him as much time as possible to do that, because otherwise we would be looking at a presumptive prison sentence.
Okay. Do you know how much money's left owing? Mr. Carter, do you know how much?
Well, when I was here one time before, Your Honor, you told me I can do community service for what I owe them. And I completed that. And you told me to bring it back, and that's the time I come.
Good.
And this
Okay.
is it right here.
Probation, can you bring us up to speed?
Yes, sir. Looks like that he owes $1,123.20. Now,
Did he-
as far as community service work,
Right.
was that turned into probation office?
Right.
Did you turn that into your officer?
Yes, they gave me a copy. That's a copy.
Okay, all right. Let me check with her because I'm not seeing that in the system.
So do you want to pass Mr. Carter for a few minutes?
That would be
And then
fine,
come
Your
in